Okay, thank you all for joining us at IBIL's brand seminar for 2015 on the average consumer. From my point of view, the aim of this evening is to answer a number of questions. So what I'm hoping we'll get out of the evening is we'll understand who the average consumer is, how clever and careful, if those are the right words, he or she is, and what difference this makes, how we can actually understand what's going on inside their head, whether context makes a difference, whether there is one average consumer for each product market or there is a range of people who may have different characteristics, and also how other jurisdictions solve these problems. And I'm really very delighted that we have such an excellent panel here to join us to discuss these things. First of all, we have James Mellor QC of 8 New Square, who will be talking about the average consumer generally. He's an engineer by training who specialises in all areas of intellectual property law. In relation to trademarks, he has particular expertise in parallel imports and passing off. Mr Justice Arnold, who I think is well known to us, will be talking about the average consumer in passing off. He was appointed to the High Court in October 2008 and as judge in charge of the Patents Court in April 2013. He has written very widely on a number of issues, including for relevant to our purposes, particularly in unfair competition. Professor Dev Ganji from the University of Oxford will be talking about the average internet consumer.
Please, it doesn't seem to be working.
Okay, all right, sorry. Professor Dev Ganji from the University of Oxford will be talking about the average internet consumer. Dev has written and consulted widely to all manner of people on trademarks and geographical indications. Jenny Barker will be talking about the average pharmaceutical consumer. Jenny is Assistant General Counsel in the Global Trademarks Department of the pharmaceutical company GlaxoSmithKline. There she has global responsibility for both contentious and non-contentious issues regarding various aspects of GSK's pharmaceutical trademark portfolio. Speaking on the average German consumer is Alexander von Mullendal, now of Bardell Pagenberg. He was formerly Vice President of OHIM before that. He headed the Division of Trademark and Unfair Competition Law at the German Ministry of Justice, and even before that he was conducted academic research at the Max Planck Institute. Rounding off, we have Professor Laura Heyman talking about the average US consumer. Laura is Vice Dean and Professor of Law at William & Mary Law School in Virginia in the US. She was previously Assistant General Counsel at America Online, and prior to that she was in private practice. And after that, hopefully we'll have some questions and discussion, and we'll round off with drinks upstairs in the City Chew common room. But if I can ask James, please, to start.
Well, I'm told we're sticking strictly to time this evening, so better get cracking. Now, the average consumer and his or her characteristics were first spelled out by the European Court of Justice back in July 1998. So you may think, well, why are we talking about the average consumer now? And that's one of the three topics I want to cover this evening in my 10 minutes. Why the UK fascination with this topic now? And as part of that, I'm going to discuss the different possible connotations of the word average. And I also want to look at the genesis of this concept in the ECJ case law. And finally, I'll address the question, can you have more than one average consumer? Now, one of the messages I want to get across this evening is that the average consumer test is not a statistical test. But in order to demonstrate that, I'm now going to descend into a statistical analysis. Okay? So, as you probably know, the average consumer is pressed into service whenever the court or a tribunal has to consider the perception of a mark or a sign from the point of view of a member of the public. So let's assume we want to do that. We want to analyse the perception. And make it absolutely clear this is very much an idealised scenario. So the first if is this. If we could interview a very large population of consumers, and if we could accurately record their views but without skewing the results, and if their responses could be graded fairly and precisely, and those are three very, very big ifs, and they're part of the reasons why statistically significant surveys fell out of favour back in the late 80s and 90s. But if we could do all of that and plot their responses, they'd probably look something like this. Now, normal bell curve, normal distribution, where you've got, let's assume for the purposes of my talk, the people at this end are extremely knowledgeable, very careful people. People at the other end are ignorant, careless, what Mr Justice Foster used to call morons in a hurry. And then you've got a range of people in the middle. Now, very careful people, very knowledgeable people are unlikely to be confused between the mark and the sign. The ignorant people are quite likely to be confused, and you've got a range of people in the middle. But if you've got, say, 20% in the middle who are confused, and you've eliminated the outliers, is that 20% enough? Well, it's not enough if average means a mathematical average, i.e. mean, the top of the curve. And it may not be enough if average means most people. Because if you take a statistical analysis and you take plus or minus one standard deviation from the mean, you are covering about 68% of the population. Do you need to show effectively more than 50% of people are confused? Or if you show some proportion in the middle, 15-20%, is that going to be enough? Well, one of the reasons why we are discussing these issues and the various different meanings of what average can actually mean is because, and you'll have probably worked this out already, there are certain of these meanings that suit a defendant's argument. So, for example, if the average consumer test requires the court to employ a single meaning rule, which would mean average means a mathematical average, or if the average consumer test requires you to show that most consumers are confused, then the defendant can win if you've only got 20% of people actually confused. Now, these arguments got a significant leg up from certain paragraphs in Interflora No. 1, Lord Justice Lewis in the Court of Appeal. Now, it's not entirely one way because there are indications elsewhere in the judgment that the judge didn't quite mean this. But the problem with this paragraph 35 is that the way he uses the word average in the last phrase, it can really only be understood as the judge having a mathematical average in mind. And I've noted the date of the hearing was 7th of November 2012. That was the day after the US presidential elections. It was so Obama got his second term on the 6th of November. And it was perhaps unfortunate that this example obviously came up in argument and was reproduced in the judgment, because that is not a helpful analogy. And I think it led to this connotation that, yes, average meant a mathematical average. Now, if you go back into the case law of the ECJ and you look at the genesis of the average consumer, it's actually very clear that it's not a statistical test and it's certainly not a mathematical average. Now, Gut-Springenheide was a consumer protection case where the phrase at issue was describing eggs as 6 grain, 10 fresh eggs. Was that likely to mislead consumers or not? And one of the questions posed to the court, and I think Alex has got the full set of questions Alex has got the full set of questions in his slides. So this is a bit of a paraphrase, but essentially one of the questions the court had to deal with was the level of attention, care and knowledge. Was it, and this is the English version of the questions, was it the view of the informed average consumer or that of the casual consumer? And in fact, the distinction is even clearer in the French, the language of the court, consommateur moyen informé, or consommateur superficiel. So that was the choice that the court was asked to make, and perhaps not surprisingly, it came up with its characterization of the average consumer. Average consumer, reasonably well informed, reasonably observant and circumspect. Now on the way out, anybody who can't recite that mantra will not be allowed to leave. It's also instructive to look at the case just after Gut-Springenheim of Estee Lauder. Very similar issue. Again, a consumer protection reference. It concerned the use of the word lifting in relation to a face cream. Was that lifting cream for daily use, would that produce, or would consumers think it produced permanent effects? One of the reasons for the reference was because, as I understand it, under German law, you'd have to have a proportion of consumers confused which was greater than 10 to 15%. Now, as it usually does, the ECJ just simply repeated its guidance from Gut-Springenheim. But the Advocate General's opinion is well worth a read, particularly at paragraphs 29 to 30, because there's a very strong element of don't be so daft in his opinion. But the one thing he made very clear is the approach is not statistical. Okay? So the answers were there all along. And we've now got back to that position. And this is a summary, at least my summary, of where we've got to in the UK. I mean, first of all, back in 2004, Lord Justice Jacob described the average consumer test as the ordinary consumer test. And by that, he was trying to get across this idea that it's a typical or normal consumer. Certainly not statistical or, in any sense, mathematical average. It doesn't mean that there's a single meaning rule. It doesn't mean there's a binary test, i.e., is the average consumer confused or not? And it doesn't require you to demonstrate that most consumers will be confused. A significant proportion may be enough. And I've given you the references there. Bearing Richard Arnold's blushes, in the first instance decision, there's a very solid set of reasons as to why there can't be a single meaning rule. Lord Justice Kitchen's judgment in the Court of Appeal is, let's say, more nuanced, more diplomatic, because he made a noble attempt to try and reconcile Lord Justice Lewison's judgment with the case law of ECJ. Not entirely convincing in my view, but nonetheless the message is clear. And if you want the very latest word, again, it's Richard in the Supreme, I think it's rabbit food, case of rabbit food. Anyway, just going on to my third topic. The two cases I want to talk about very briefly. The first one is Schutz and Delta. This case concerned rebottled intermediate bulk containers. So Schutz, the trademark owner, would send out the cage and one of their bottles. And as you can see, they put their trademarks all over both. And people like Delta would take the cage, throw away the Schutz bottle because it was usually contaminated, put their own bottle in. Now, the trademark side of the case turned on this issue. Would the cage be taken by the average consumer to be use of the mark on the cage, would that be taken by the average consumer to be used just in relation to the cage, or the IBC as a whole? And there were two distinct classes of people in contention. There were the end users of these IBCs and those who filled them. And there was a very clear distinction between these two classes, because the end users thought that the Schutz mark was used in relation to the IBC as a whole, whereas the fillers didn't, usually because they dealt directly with Delta. And these facts set up the issue beautifully, actually. And Mr. Justice Briggs, as he then was, said this in his judgment. And this paragraph is a very succinct and correct summary of the position. And I'm just going to focus on the words I've underlined. So first of all, he said, it's not a statistical average. Absolutely right. In the next bit, what he's basically saying there is you discard the outliers. So if you just cast your mind back to our normal distribution, you cut out the people who are very knowledgeable at one end, and you cut out the morons in a hurry at the other end, and you look in the middle. And in that last sentence, you notice the words within any relevant class. Now that encapsulates the idea that a significant proportion of those people in the middle will be enough. Okay, I've been told to stop, but I'm just going to talk about Betty Boop very quickly. Because this was the case where the defendants started to license images of Betty Boop, and the word Boop, into a market that the claimants had been developing for 25 years. And the issue was, who's the average consumer? Well, there were three possibilities. The first possibility was the licensee's actual intention of the first defendant. Second, retailers, and third, consumers. And just very briefly, for the cause of action of passing off, all three groups were relevant average consumers. So you had three different groups of average consumer. In the trademark case, only 2 and 3. And if you haven't worked out why there's a difference, maybe we'll deal with that at the end. So thanks.
Right. As advertised, I'm going to talk about the average consumer in passing off. For those of you who haven't read it, I've just recently dealt with this subject in a case called Enterprise and Europe Car, January this year, and the relevant paragraph is paragraph 158. And you will find, if you look at that judgment, that there is treatment of the subject of the average consumer, both in the context of trademark law and in the context of passing off. And you will find there is a certain degree of similarity between the two. This is not an accident. You may think that the average consumer was invented by the Court of Justice of the European Union in 1998. Not so. The concept was known to the English law of passing off 149 years ago. The case in point is called Seiko and Provosendi. It was a case in which the claimant was Baron de Seiko. He was a Portuguese nobleman, and as you might guess, he produced port, and he exported a lot of his port to this country in casks. The casks were stamped with crowns and with the word Seiko. The defendants obviously saw a market opportunity, and so they decided that they would start selling port in competition with the Baron. And they sent port to England in casks, stamped with a coronet. Quite what the difference between a coronet and a crown is, I'm not quite sure, but clearly it was a similar symbol or device. And the casks were also stamped with the words Seiko de Chima. Not surprisingly, the Baron took umbrage, and he brought a claim for passing off in the Court of Chancery, as it still was at that time. And he came before the Vice-Chancellor and was successful. The defendants appealed, and they came before the Lord Chancellor, Lord Cranworth. And I'm going to read you a short extract from his judgment, which is of interest from a number of points of view, but is particularly relevant to our subject this evening. And he said this: if the question turned on the inquiry whether a person having a cask of the plaintiffs and a cask of the defendants placed before his eyes could mistake the one for the other, there could be no doubt as to the result, for the marks on the one and on the other are altogether different. But that is not the question, or not the sole question to be considered. The principle on which relief is given in these cases is that one man cannot offer his goods for sale representing them to be the manufacture of a rival trader. Supposing the rival to have obtained celebrity in his manufacture, he is entitled to all the advantages of that celebrity, whether resulting from the greater demand for his goods or from the higher price which the public are willing to give for them, rather than for the goods of other manufacturers whose reputation is not so high. Where, therefore, a manufacturer has been in the habit of stamping the goods which he has manufactured with a particular mark or brand, so that thereby persons purchasing goods of that description know them to be of his manufacture, no other manufacturer has a right to adopt the same stamp. By doing so, he would be substantially representing the goods to be of the manufacturer who had previously adopted the stamp or mark in question, and so would or might be depriving him of the profit he might have made by the sale of the goods which ex hypothesi the purchaser intended to buy. The law considers this to be wrong towards the person whose mark is thus assumed, for which wrong he has a right of action, or, which is the more effectual remedy, a right to restrain by injunction the wrongful use of the mark thus pirated. It is obvious that in these cases, questions of considerable nicety may arise as to whether the mark adopted by one trader is or is not the same as that previously used by another trader complaining of its illegal use. And it is hardly necessary to say that in order to entitle a party to relief, it is by no means necessary that there should be absolute identity. What degree of resemblance is necessary from the nature of things is a matter incapable of definition a priori. All that courts of justice can do is to say that no trader can adopt a trademark so resembling that of a rival as that ordinary purchasers, purchasing with ordinary caution, are likely to be misled. It would be a mistake, however, to suppose that the resemblance must be such as would deceive persons who would see the two marks placed side by side. The rule so restricted would be of no practical use. So there's the Lord Chancellor in January 1866, setting out for you in a couple of paragraphs the whole essence of the law of trademarks. He has the mark as an indicator of origin. He has reputation. He has the public being misled. He has imperfect recollection. And importantly, for present purposes, he says, when it comes to this difficult question of deciding how close is too close, how similar is too similar, the standard to be applied is that of, and I quote again, ordinary purchasers purchasing with ordinary caution. In other words, as we would say now, the average consumer who is reasonably well informed and reasonably observant. Now, the phraseology of the ordinary consumer is one that you can find resonating down the cases in the area of passing off. And sometimes the formulations come extremely close to the language we are now familiar with. One that particularly struck my eye looking through some of the historic cases was actually a case from New Zealand. It's a case called Hansel's New Zealand Limited at Bailey. This was a case from 1967. So again, quite some time before the Court of Justice got its claws on this area of law. And the judge in that case, Mr Justice Haslam, said that the question was to be considered from the perspective of, quote, the average prudent person with proper eyesight and reasonable apprehension. So again, you can see pretty close to the current formulation. Now, before moving on, it is worth remembering that in Reckitt and Coleman and Borden, Lord Oliver said, and I've just realised I've left a quote over here, so excuse me, said this was of course the Jiff Lemon case. The essence of the action for passing off is a deceit practised upon the public, and it can be no answer in a case where it is demonstrable that the public has been or will be deceived, that they would not have been if they had been more careful, more literate, or more perspicacious. Now, that is not in any sense an inroad into the principle that I've been articulating to you. On the contrary, it's the flip side of the same coin, which is to say, when you consider matters from the perspective of the ordinary purchaser, purchasing with ordinary caution, you are setting a level of perspicacity, a level of attention, if you will, and it doesn't help the defendant to say, well, people who exercise more care, more attention, would not be misled. Now, the other aspect of the matter, which again is a very long-standing, we can trace back at least as far as 1899. And the case in point here is Peyton & Co. Limited and Snelling Lampard & Co. Limited. This was a case about coffee tins. And the claimant in that case sold coffee in tins that were in 3 colours. And guess what? They were red, blue and green. And they used the word mark Royal, which was prominent upon their tins of coffee. And the defendants came along, and they also sold coffee. And they used the trademark Flag. But they had the astounding audacity to use red, blue and green for their tins of coffee. And as a result, for their pains, they got sued for passing off. Surprisingly, you may think, the action was successful at first instance. However, the case subsequently went to the Court of Appeal, and then, believe it or not, to the House of Lords, where sense prevailed, and the defendant was the successful party on both occasions. Now, for my purposes, what matters is something that was said by Lord Justice Roma in the Court of Appeal, where he said this: it seems to be a sort of popular notion of some witnesses that in considering whether customers are likely to be deceived, you are to consider the case of an ignorant customer who knows nothing about or very little about the subject of the action. That is a great mistake. The kind of customer that the courts ought to think of in these cases is the customer who knows the distinguishing characteristics of the plaintiff's goods, those characteristics which distinguish his goods from other goods on the market so far as in relation to general characteristics. The customer must be one who, knowing what is fairly common to the trade, knows of the plaintiff's goods by reason of these distinguishing characteristics. If he does not know that, he is not a customer whose views can properly or will be regarded by this court. So in other words, it's not merely that you are concerned with the consumer who is purchasing with the ordinary level of attention. They have to be reasonably well informed, to use the language of the Court of Justice as well. And that entails knowing that which is fairly common in the trade. But there we have it. As late as 1899, we have all the essential ingredients of the average consumer recognised and being applied by the English law of passing off. And there I will stop.
There are some seats in the second and third row from the front if anybody needs them.
Okay, thank you. I'll get going as well. I'm going to pick up on a theme that James introduced at the beginning, which is why is the topic so relevant now? And I think one of the reasons why it's so relevant at the moment is there's a tussle going on, a debate between the extent to which the average consumer is empirical or empirically informed, or alternatively some kind of a notional legal construct closer to the tort idea of a reasonable person. And really trademark law seems to be stuck in between this kind of oscillation at the moment, and courts are working through that problem. So I'm just going to pick up on these two issues and work through them in the context of the average internet user. And I'm going to end by saying maybe the average internet user is the wrong person all along, so I'll just warn you about that. So the origins of the internet user, so this is familiar stuff. I'm going to skip through the first few slides quite quickly. The origins of the internet user can be traced to the Google France case. There are sort of older German authorities which talk about it in the meta tags or domain names kind of context. But this is really where it gets the lights and bells and whistles. It's the Court of Justice in Google France, which says, for the purposes of double identity, where the keyword ad doesn't enable an average internet user, that's where we see the person entering, or enables that user only with difficulty to ascertain the source of the goods or services, or whether the advertiser is linked to the trademark owner, or alternatively whether it originates from a third party. If there's that fuzziness, Article 5.1a double identity is triggered, and we see the average internet user making an entrance in two contexts. Article 5.1a, which is the double identity rule, and specifically in the context of keyword advertising. So I'll just flag that up at the beginning. We then see the notion of the average internet consumer mainstreaming and being equated with our average consumer, who's already been spoken about by the previous two speakers, and that's most clearly seen by the Court of Appeals in the latest Interflora decision, the 2014 decision, and they say that the two concepts can be equated. The average consumer and the average internet user, both are reasonably circumspect, reasonably well informed. But what's interesting about the average internet user, what sets it apart from the general average consumer, is the context. And the context has the potential to be informed by empirical evidence. So what's different about the internet context, and what makes this this consumer/user different? There's something about the medium and the interaction, the process of using that medium, which is important. And I think it's picked up by Mr. Justice Arnold, by Richard in his 2013 decision, where he uses an array of empirical evidence to put together the context around this consumer and the way in which that person makes decisions. So the internet literacy in general, what's the internet literacy like for the adult population? And there's interesting sort of revelations in there, but things that once you see them, you understand that they make sense. Factors like age, and you've seen sort of the facility of children with tablets that describes at home, socioeconomic background, and the fact that internet literacy is dynamic. So it flags up one of the issues which the general theme I set out earlier is trying to address. Empirical evidence may be relevant and certainly has a strong place in setting the context around which this reasonable or hypothetical or notional consumer makes a decision. And it's evidence like this which helps us set up the context. The other is the user or consumer understanding of keywords. And the core point which emerges from this evidence is many users, internet users, cannot distinguish between paid or sponsored ads and the natural organic results. And I'll come back to this issue and ask whether it really is a big deal. What's missing from this understanding of context, the word that's missing, and the reason why I asked if we're looking at the wrong target, is repeatedly at different points in different decisions. In Google France, in Porter-Cabin, in Bergspect, the Court of Justice says when we're talking about the average internet user, we're really talking about a searcher, someone using a search engine. And the verb bit of search is important, and I want to come back to it later, because otherwise the consumer's a bit of a lump. She or he sits there and gets stuff chucked at them. But the moment you start talking about a searcher, there's a little more activity involved, and that's a point I want to get back to. In terms of the consumer being this hypothetical or normative construct, we see it really developed or elaborated in the context of Article 5.1a, which is the double identity claim. It's a vehicle to develop this. And I think, for what it's worth, I think that Richard got it right in the Interflora trial decision in 2013, where he said that the purpose of the Court of Justice setting up its test under Article 5.1a was to tidy up internet advertising. I think the Court of Justice got it wrong in trying to make trademark law do this, but I think that's the most reasonable reading of what the Court of Justice was trying to do in sort of putting the onus on advertisers to tidy up their advertisements. It assumed that consumers, the average internet consumer in this case, viewed keyword ads in such a way, such that harm to the origin function was found, and it was more likely in situations where the search term was present in the search box, the ad had popped up, and the proximity between the two was likely to lead consumers to make a link, which was potentially of the kind that damaged the origin function. The court also talks about the need for transparency in the e-commerce context. They really seem to be pushing advertisers to clean up their acts. Confusion per se becomes sufficient. What the court is trying to get at is if the ad is fuzzy about who it's from, then that's enough to trigger Article 5.1a, and we'll use the consumer understanding of advertisements as the vehicle to reach this outcome of tidying up internet advertising. So they spin the consumer in a particular normative way to reach the normative outcome of tidying up internet advertising. And you can see that maybe this is what they're trying to do, because courts subsequently across the EU then grapple with the question of when is an ad tidy enough? And the answer seems to be when the format is correct. So it becomes a correct format for the advertisement type debate, which is a formalistic, sort of prescriptive debate saying this is the way advertising should be, rather than what consumers really think. And it's a different kind of question. So you use things like, does the ad use the trademark in its text? Should the advertiser put up a disclaimer? Is the fact that it's in the golden box for ads sufficient to set it apart so that consumers know the ad is not for the trademark owner? You get into the formalities around the ad and the context, and it becomes a prescriptive kind of debate, drifting far away from a more empirical understanding of the consumer. So once you return to the idea of an empirically informed consumer, you start using searcher instead. You start considering this reasonable person, again this construct, but a construct as a searcher to be more active. You start asking, it's not just the consumer lands up miraculously before the search engine page, the SERP. How did the consumer get there? What were they thinking when they typed in the search term? Were they looking for corporate news about the company? Were they looking for product reviews? Were they looking for comparative sort of competitor products? I typed in sort of spontaneous arrival or spontaneous. I was trying to get an image from Google Images. So sort of spontaneous presence is what I typed in, and I got some crazy results, sort of drifting in sort of strange directions. But the idea is sort of ideas about the watchmaker in the universe and things just suddenly appearing at a certain point in time. If you start looking at people as searchers, you start tracing that back and asking about their motivations, asking about what they do after they get to a search page. Search is an iterative process, and that starts mattering more. Once we start looking at them as searchers, we also start looking at things like cues and behavioral changes. So we know that Google does things like this. If people are not just passive consumers or users, but active searchers, you start coming across, Google does things like this. And how to tell potentially throws up how to tell if your cat is spotting the key. So if ItCat is reporting this for the blog, I apologize in advance. That sort of wasn't intended to be anything against sort of the blog. The context then, as a searcher, the context starts giving you feedback cues and changing the way you respond. If you click through and you don't get what you're looking for, you go back and you try again. And we also have evidence from the eye tracking, the people who do the eye tracking experiments. And they show that how people view search results screens has changed over time. So the red is the hotspots, and you can see that the red is moving down over time because you have different things appearing at the top of search pages. You have, for example, information boxes. If you type in weather, Google automatically gives you the weather of the city you're in a box. It's changed the format of its search page, results page. So how people view that results page changes over time. Handheld devices have changed the way people view search pages as well. So if you start looking at people not as just average internet users, but as searchers, a whole different set of contextual questions, also generalizable empirical questions, context-setting questions, but a different set of contextual questions arise and may be more relevant. The final thing I'll address is the difficult set of questions, which I am just going to throw open and maybe we can kick them around during the questions and answer session. We have this fairly sensitive, relatively easily confused notional internet consumer, especially in the Article 5.1a context. Are we seeing the genie being let out of the bottle? Is it slowly leaking out of the Article 5.1a context and beginning to enter the mainstream likelihood confusion test via something like initial interest confusion? And is that a direction we want to be heading in? Is it moving outside of the keyword context to other contexts as well? So once we set up consumers with specific attributes, in particular legal contexts, specialized consumers, do they start leaking outwards? And is that something we want to have? Thank you.
So Ilanah's instructed us all to take 10 minutes exactly, but she didn't say the clock doesn't work at the back of the So I'm in-house counsel at GSK, Pharmaceutical company, and I'm going to talk briefly, can you hear me okay actually? I'm going to talk briefly about the average pharmaceutical consumer. And I think just by way of background, I think it's helpful to talk about how pharmaceutical products differ from perhaps the majority of average consumer products in the market. And I think the first differentiating factor is the variety of channels of distribution. So you've got prescription-only pharmaceutical products. So you'll go to your GP, the GP will perhaps do a handwritten prescription or a computer-generated prescription. You'll take that to the pharmacist who will dispense the product, but you as the patient don't actually select the product. And then you might have a prescription pharmaceutical product which is dispensed within the hospital environment, where it is dispensed directly to the doctor or to the nurse, administered to the patient without the patient ever even perhaps seeing the product or even knowing if they're in surgery that the product is being administered. And then you can compare that with, of course, the over-the-counter drugs that you can purchase. You might go to your pharmacist and ask for them to give you what you can see behind the counter. You might pick it up in Boots or Superdrug, and you might even pick it up as part of your supermarket shop in Tesco's or Asda. Or you might even buy the product over the internet. I think the second key differentiator for pharmaceuticals is that it's a highly regulated environment. So not only do you need to obtain regulatory approval for marketing of the product, but also approval of the name that you're proposing to use for your product. So, for example, if a product you're going to be selling in Europe, you need to obtain the approval of the name review group of the European Medicines Agency, and they will give the proposed name a rigorous examination as to whether or not there are any patient safety concerns over adopting that name, and that will include perhaps looking also at how the mark will look when handwritten and whether that would cause any confusion with existing marketed products. And I think the third key differentiating factor, of course, is with drugs. If you do take the wrong drug, it could actually have very serious consequences and can even be fatal. I mean, prescription errors are widely documented. These are just two examples. The first one, very sad case of a 9-year-old girl who died after she was prescribed Moxinol instead of Demerol. The second one, where Isodil was prescribed instead of Plendil, resulting in the heart attack of the patient. And these prescription errors do engender quite a lot of debate over whether or not, in the pharmaceutical sector, should we actually be establishing a lower threshold for likelihood of confusion because of these potentially fatal consequences. So, who is the average consumer? I think it goes without saying for any prescription or any drug that the consumer will include doctors, pharmacists, any healthcare professionals. And for an over-the-counter product, of course, it must also include the end consumer, the patient who's buying that product in the supermarket or in Boots. But what about prescription-only products? Does the average consumer also include the patient who hasn't necessarily selected the product from the shelf? And of course, if you're looking at trademarks, you're going to be looking at the specification, and often that would be a wide specification. It might just be for pharmaceutical products, and arguably the pharmaceutical products end consumer is going to be both the patient and the healthcare practitioner. But when it comes to actually proving your use, when you're put to proof of use of the product, often then it's shown that your actual use is much narrower. So, for example, in the Recipe Court case, this is a case around inhalers, and the Board of Appeal came to the conclusion that the deemed specification should be limited just to multi-dose dry powder inhalers containing corticoids, which would be a product that would only be available on prescription. But when it went to the court of first instance, they found that that was too narrow and that it should be deemed to have a much broader specification. So it would be therapeutic sort of products for treating respiratory ailments. So much broader, something that would clearly be aimed at both the patient and over-the-counter products and prescription-only medicines. So I think at the end of the day, in reality is that for pharmaceutical trademark cases, the end consumer does tend to be both the healthcare practitioners and the patients. And the only exceptions to that seem to be where, in cases like the Alcon case, where the specification was very narrowly drafted. So the product was protected only in respect of solutions for use in ophthalmic surgery. And so in that instance, the court did decide that the average consumer was limited just to ophthalmologists and ophthalmic surgeons. So I think we've established that, generally speaking, the average consumer will be both the healthcare practitioner and the patient. So how attentive is the average consumer? I think it's established case law that healthcare practitioners will have and display a high degree of attention when they're prescribing medicinal products, which is what you would expect. But what of the end consumer, the end patient? There's certainly been quite a debate in the cases, and there are a number of cases, certainly in the UK, where there's been a recognition of a tension between, on the one hand, perhaps we should ascribe a lower degree of attentiveness because of the potentially fatal consequences of confusion, balanced with, or versus, ascribing a higher level of attention to detail because it concerns the patient's health, and so they're going to be more attentive to what they're purchasing. And certainly in the Omicron decision of the UK IPO, they recognise that really it's down to the regulators to look out for patient safety. It's not for the courts to intervene on that, and that these two conflicting factors really balance each other out. And that what we should be left with is what we've all been discussing today, is really the reasonably well-informed, reasonably observant and circumspect consumer, not one with a heightened level of attention to detail. But the European cases have certainly departed from that. It's a line of cases, most recently the Biosec and Biosert case, where, so starting with the Respiracort case that I mentioned earlier, this dry powder inhalers case. The court there said, well, this case concerns products which are for treating potentially very serious illnesses, and therefore the patient is going to be particularly attentive to what they're taking. And the implication of that is that the more serious the ailment that the product is destined to treat, then the more attentive the consumer. But then we have subsequent cases where the courts have said, for example, in the Topanol case, where it was to do with headache and migraine treatments, which were available over the counter, where they said even though it's available over the counter, we should still ascribe a heightened level of attention to detail on the part of the consumer. So I think that's where we stand at the moment. So just very quickly, the last thing I was going to say, in terms of the pharmaceutical consumer, there are also a number of cases which talk about the extent to which the average purchaser of a pharmaceutical product will understand the elusive signs in the drug names. And this is something that does happen with products. So, for example, Botox refers to the active ingredient, botulinum toxin. And there are cases where, on the one hand, prefixes are agreed by the courts as something that the average consumer will understand as alluding to the underlying either disease that it's aiming to treat or the active ingredient. And then we've got a line of cases where it's been considered that only the healthcare practitioners will understand those suffixes or letter strings as related to the underlying active ingredient. So just to sum up, average pharmaceutical consumer, so it's comprised both of the healthcare practitioners and the end consumers. is reasonably well informed, observant and circumspect, but does have this heightened level of attention to detail, and understands that it's a common practice to use elusive or suggestive elements as part of the brand names. But to what extent that will be the case will depend very much on the actual facts of each case. Thank you very much.
Well, good evening, good afternoon. I look at this watch, by the way, it's 10 past 10, I can't believe it. I have 10 minutes and I will go by this watch and hope to stick with these 10 minutes anyway. I've been asked to deal with the German consumer. Of course, German consumer is part of the European consumer anyway, but it is perhaps useful to point out some of the differences or the approaches that have been taken by German courts over time, and to contrast that with what you had heard previously. I have some remarks on the German population, then some of the legal development, and I deal with the issue of is the average consumer an issue of fact or of law, what is with the majorities required, and what happens in what is called in Germany gespaltene Verkehrsauffassung, when there is no uniform understanding in the public of what a particular sign or mark means. Statistically, Germany has some 18 million inhabitants, of which 74 million are Germans. They are German citizens with immigration background, some 10 million, and there are foreign nationals of about 8% overall. And if you are interested on where they come from, I don't know whether these slides will be made available for those who want them. I donate them to the Commonwealth. You find perhaps some interesting data in that you may not be familiar with. You also have, of course, when you look at a population, you have the famous population tree, the distribution by age and by sex. And you see, of course, that there is some distinction between the female side and the male side. That is the, if you wish, the statistical background against which we look at when we talk about the consumer in German law, where I speak about trademark law, but also about unfair competition law. German unfair competition law has a very long history, not quite as long as English passing off. The first statute dates from the end of the 19th century. The basic law on unfair competition in Germany is 1904, which is also about the same time that trademark law was adopted. And the consumer, or the trade circles as they are also called, have been an essential element in both of these fields of law from the very beginning. Again, the Court of Justice is entering this field at a rather late stage, and against the tradition in Germany, which has, by the way, changed as a result of the Court of Justice's case law. In unfair competition law, the issue is protecting the competitors, protecting the public from unfair acts, practices, or misleading activity. Where in trademark law, the situation is different. It's not a consumer protection law, it is a law which protects the proprietors of trademarks against unfair taking of their goodwill in the broadest sense, but much more mechanized in opposition and in validity proceedings. So actually one could say that you should look at the consumer as the standard against which to measure outcomes of cases a little bit different from unfair competition law and trademark law. But the Court of Justice in the European Union has a habit of interpreting the same term across all different kinds of legislation with the same meaning. So they have applied the likelihood of confusion standard in the misleading advertising directive in the same manner as they do in the likelihood of confusion standard in the trademark law. And this is also true for our average consumer. We heard the origin of this element of this notion coming from Gut Springenheide, Gut-Springenheide is an interesting case, by the way, because it was a reference from the German Bundesverwaltungsgericht, the Supreme Administrative Court. You wouldn't expect them to be involved in misleading advertising, but it was a prosecution against a person under some labeling law that are food administration, and he was given an administrative fine, and the case went up to the Bundesverwaltungsgericht. And I have, indeed, as it was said, we come to that and perhaps a little later, the exact question that was presented there. The German tradition, both in unfair competition and trademark law, was to take into account the casual, flüchtige Verbraucher, and they considered traditionally sufficient when you talk about numbers, figures between 10, 15, 20% of that particular type of consumer to which the message or the mark was addressed, sufficient to grant relief. Now, people have said, well, 10 to 15% and the inattentive consumer makes for bad law. I just invite you to consider when you have 80 million in the population, and of the inattentive ones, 20% are misled. That amounts to 16 million people. Question whether that's really insignificant remains to be seen. There came a case to the Court of Justice in 1984 involving protection of a bottle shape, and the lawyer on behalf of Mr. Prankel, who actually was the plaintiff and the victim in that case, described the German law as being based on the image of an infantile, almost pathologically stupid and negligently inattentive average consumer. And it seems, while this of course did not enter into the case law, that the impression that was created in the courts in Luxembourg was that the German law was overly protective towards the inattentive consumer. And then comes the Gut-Springenheide case, and since that time, and it is all recognized in the German case law, we apply the same standard everywhere, namely the normal informierte, angemessen aufmerksame, verständige Durchschnittsverbraucher. That is the German translation of the average consumer, reasonably well informed, observant, and circumspect. If you look at it, this particular figure, this notion in trademark law, I think it is useful to keep in mind that we have different areas of trademark law where the consumer plays a role. It's registrability. What is a sign? Is the mark distinctive or not? Is the mark descriptive? Does the mark mislead? That is the one area of inquiry. On the scope of protection issue, you have the likelihood of confusion on the part of the public to which the mark is addressed. That is similarity of marks, similarity of goods, services, the degree of distinctiveness, degree of attention of the relevant public, which we heard about in the pharmaceutical case, very complicated. You also have the limits, fair use of descriptive terms, and you have loss of rights. When is a mark considered to be generic? All of these have to be looked at. The court further has established that there must be a substantial proportion of the relevant public which must be taken into account. So there is a quantitative element in the substantial proportion in there. Question there is, what is substantial? Is that substantial requirement really appropriate for all circumstances? Registrability of terms known only to a very small section of the public have been routinely refused by OHIM and confirmed by the court, even though most of you will have problems in knowing what Hallux is or where Port Louis is located. Acquired distinctiveness. German courts have traditionally required a substantial majority, actually, of the public to know a trademark before they grant acquired distinctiveness. If you look at the Court of Justice most recently, they have consistently refused to accept any statistical analysis of where the level of substantial significant proportion of the public lies. This is, for those who later want to read it, the Gut-Springenheide question, and that's where the answer comes from. And which brings me to my next to last question, that is the average the notion of this reasonably informed average consumer, is that a question of law or fact? And the Court of Justice in the Wutsch-Bringenheiser case, interestingly, said, we have decided a number of cases where the issue is clear. We have ourselves said the issue of misleading is decided at the level of the Court of Justice. One would have thought that they would never do that, but they apparently were of the view that it's so clear-cut that the answer can be either yes or no. And then they say, so national courts ought in general to be able to assess on the same conditions any misleading effect of a description or statement designed to promote sales, which still, of course, leaves the question open whether it's law or fact. The Court of Justice in trademark cases has basically never reviewed on substance a general court finding as regards the ordinary consumer. I have in the slides something which you may be interesting to look at separately, the German custom of making consumer surveys is still, in spite of the criticism raised in the Court of Justice, very standard practice. And here I have a listing of actually what these surveys inquire into, whom they ask, and what is the element that they're looking at. I have a final reference only for you to consider what happens if the perception of the public to which a sign is addressed is not uniform. One part considers the element to be deceptive or confused, and the other does not. And German law has an answer in an interesting case called Gazoz. Gazoz in Turkish means sparkling water, registered as a community trademark. And the question there arises, is this a valid trademark? Is it infringed, or can it be used in spite of being registered? And then I will end. Thank you very much.
Thank you very much. I have been asked to close by speaking about the average U.S. consumer. I'm not sure that there's anything particular about U.S. consumers in this respect as compared to the German consumer or the UK consumer. So I'll focus, as others have done, about how the consumer is treated in the U.S. courts with respect to these issues. And I should note, as a disclaimer, to the extent I'm critical at all and noting my esteemed colleagues' presence on the panel, I'm speaking only of U.S. judges. I say nothing about the judiciary's decisions here in the UK or elsewhere. And I also think, as Professor Ganji has noted, this is an extremely contextual question that can depend on things such as generational perception. So in my courses, for example, when my students are critical of some of the early internet cases where the judges have seemed not to understand how easy it is to hit the back button when one gets to a website one doesn't want to reach, my students will say things like, well, we all understand that, but people in my parents' generation, you know, people in their 40s, will have trouble with these sorts of issues, at which point I sort of crumble and try to go on. As Professor Ganji noted, I think that there is some similarity here between the question that we try to address in negligence law, whether someone acted with reasonable care or acted as a reasonable person, and the question that we're addressing here in trademark law. I think the difference, though, is that when we are thinking about this in negligence law, we're using the reasonable person as this sort of ephemeral standard of care that the decision maker, the judge, in many cases, may not have any direct experience with. So if the judge is not trained as a physician, for example, whether someone has acted reasonably, a physician, or committed medical malpractice is something that requires expert evaluation and expert testimony. In trademark law, we're trying to assess, ostensibly, the facts on the ground. We're trying to determine how, in a particular context, a consumer will interpret a particular mark or interpret two marks as against each other. And I think that one of the things that we see in some of the U.S. cases is that where the judge may not feel himself or herself competent to judge, say, whether a physician has acted reasonably, the judge, as a consumer himself or herself, will often in the U.S. cases decide to make that decision on his or her own and perhaps can more easily see himself or herself as the typical consumer. And this sometimes results in, I think, some unfortunate decisions. For example, the standard in US law that if the purchase involves not very much money, or if the consumer does not have very much income in making the decision, that the consumer is therefore unsophisticated or doesn't take much care in making that decision. And I think that's going to be a problem. I'll continue, perhaps someone can fix that one. The idea that someone who doesn't have much disposable income and therefore is not taking a lot of care in making the decision. Of course, if one doesn't have much disposable income, one is often taking a great deal of care in making every decision, no matter how large or how small. Any chance we can bring that back down again? I'll continue on. You can just imagine, and perhaps we can do some shadow puppets or something along that way. Comparatively, one will often say that children, for example, are not careful decision makers or careful consumers. And anyone who's ever shopped with a child and tried to pass off the non-name brand toy in favor of the name brand toy will understand precisely how brand conscious children are. I have many a friend who's tried to pass off the non-name brand food by putting it in, say, a SpongeBob SquarePants bag, right? Committing her own passing off, in fact, dealing with her children. But it's the only way that they will eat the macaroni product, for example. So we have a number of instances, thank you, where a court's view or judge's view of what a reasonable consumer might look like doesn't really match up with how things work on the ground. And I'd like to actually focus then, when we talk about the reasonably prudent consumer, and one aspect, I think, where this often plays out. And it's the idea of a reasonably linguistically adept consumer. And the ways in which, as the US courts don't always seem to recognize, that we play with language, understand language, and interpret language in ways very different from the ways in which the doctrine assumes we do, for example. One broad example is this idea that sort of standard US canon that a disclaimer is ineffective to remedy instances of confusion. The idea is that the disclaimer reinforces the idea of the confusion in consumers' minds, that people don't read disclaimers. But in fact, in tort law, we rely on disclaimers and warnings all the time. In product liability cases, we rely on warnings extensively in order to say this is what you should have done in order to help make your product safe. The idea, additionally, that English language facility, or lack thereof, means you're not a careful consumer, was something that came up in the Qualitex case. Now, this case was a US case that established the idea that color alone can serve as a trademark. These were press pads that were being used in dry cleaning establishments. And the district court, the trial court, recognized, I think quite rightly, that the color was very important in this particular context because dry cleaning establishments in the area were often run by immigrant families for whom English would be a second language or perhaps not a language they were facile with at all. However, having recognized this, the district court then went on, unfortunately, to conflate a limited ability to read English with a lack of care in purchasing decision, and said Korean and other foreign-speaking purchasers of these pads are unlikely to exercise a sufficiently high degree of care in so doing. Another doctrine, I think, that the judges in the U.S. sometimes don't fully recognize that consumers have a facility with language is the doctrine of foreign equivalence. The doctrine basically asks, when should we translate a mark that's rendered in a language other than English? The doctrine says it should be applied only when it is likely that the ordinary American purchaser would stop and translate the word into its English equivalent. Of course, if somebody understands each language equally, they are not translating it at all. They are just simply understanding one word as the other word. So, for example, buenos dias being translated or being understood as being the equivalent of good morning, perhaps is not so controversial. Likewise with veuve clicquot, the idea that the average consumer would not see that as understanding that to be the same word as widow. But then, of course, we have cases coming from the Trademark Trial and Appeal Board that the average U.S. consumer would understand lapel to be the same as leather in Italian, or that they would understand sonop, which the opinion tells me means sunrise in Afrikaans. To be equivalent, I think, attributes a certain facility in language that the average consumer probably doesn't have. Similarly, is the question of whether or not you take dialect or regional variances in English into account. Any of you who have ever traveled in the US will know you hear a very different kind of English in the South from the kind of English, American English you hear in the North. In the South, the word pen and pin will be very much identical. Right? So you think pin, right? It's unclear whether that's P-I-N or P-E-N. So in a case that you may be familiar with in the Second Circuit involving dilution, the question Lexus for the luxury car maker and Lexis for the legal database, the question is whether these two terms were pronounced similarly or not in English. The lower court had said they were virtually identical, which I think would reflect the average US consumer. And the appellate court disagreed, saying, and I quote, "The two members of the court who concur in this opinion use everyday spoken English, and we would not pronounce Lexus as if it were Lexus." Although our colleague takes issue with us on this point, he does not contend that if they are pronounced correctly, they will sound the same. And the court then quoted Lexus, first one's expert, who said, "The distinction is there to be made in ordinary, reasonable, careful speech." The fact that during the trial, counsel had to repeatedly specify which of the two facilities they were referring to, I think belies that conclusion. But again, it's an example of where the judge in that case on the appellate court had a very different view of what it meant to be your sort of average speaker of English as compared to perhaps the more rarefied version of English that the judges spoke. Finally, one thing I'd like to talk about in terms of the linguistically adept computer is the idea that consumers, for some judges, can't keep two ideas in their head at the same time involving the same word. Now, of course, we do this all the time. We allow Delta to be a mark for airlines, and we allow Delta to be a mark in the US for faucets and other sort of hardware, and nobody thinks that that's impossible for consumers to handle. The idea that you might not show up at the airport if you're looking to buy a faucet is not likely to happen. It's even true, though, with words that ostensibly linguistically are meant to refer to the same notion. So here's a map of generic names for soft drinks in the US, arranged by county. This is constantly updated at the website popversussoda.com if you'd like to participate and see for yourself. And as you'll see, in the northern part of the US, the generic term for a soft drink is pop. The red at the bottom of the US, the generic term for a soft drink is Coke. So in many places in the southern part of the United States, if you go into a restaurant and you order a Coke, the response from the server will be, "What kind of Coke do you want?" And then you can respond with lemon lime or whatever it is that you'd like to order. And that is completely understood that Coke, small c, in that context means a soft drink, whereas Coke, capital C, will mean the brand name Coca-Cola. And consumers can keep that idea in their heads at the same time, and yet the courts have seemed to suggest that somehow that sort of usage renders Coke generic, which of course is ridiculous. We see this as well, for example, in the idea of Xerox. So very common, I assume here as well in the US, if you want to photocopy a document, you might say to someone, "Could you please Xerox that for me?" Yet still recognizing that Xerox is the manufacturer of a particular brand of photocopier. The same with Photoshop, right? The photo editing software. We use that term in a generic verb sense to talk about the idea of editing digital photographs, yet still recognizing that Photoshop is the manufacturer of one particular type of photo editing software. And Google is a perfect example of this as well. So I'm going to close with a recent case that you may or may not be familiar with, and if not, you may find it of interest. Last September in the District of Arizona. We do this, by the way, all the time. We call it, in linguistic terms or rhetorical terms, anthemeria. It's the idea that we transform nouns and adjectives into verbs constantly. The word chill is an example of this. Chill, the noun, you had a chill, And now, then we transform chill into something you would do, let's say, to a wine, right, or a drink. You would chill it. And now, of course, my students and perhaps others tell each other to chill all the time. And that's transforming this idea of a noun into a verb. And we do that with trademarks all the time. It doesn't mean that the trademark has been rendered generic. And one court recently, I'll highlight, the Vanguard, here's an example of an ad from Vanguard where they do this themselves in advertising. The idea that they've taken their mark and made it into a verb. Google made a joke about this a few April Fools ago. So when Google was looking for where it was going to set up one of its new fiber optic broadband networks, it mentioned that it was perhaps going to choose Topeka, Kansas as the location for that new network. Topeka, in response, said they would be willing to change the name of the city to Google for a month as a joke. And as a counter joke, Google responded on April Fools by saying that they had changed their own name to Topeka. But what's interesting about this is they then gave some proper Topeka usage, which of course mirrors the conventional wisdom that you should never use the trademark as a verb, so you should do a Topeka search or Topeka him with a capital T, but never with a lowercase letter, and never in connection with a competitor search engine such as Alta Vista. This now comes to a head in this case called Elliott versus Google, where, again, in the District Court of Arizona, September 2014, where the Google trademark was challenged as having become generic because, the argument went, consumers use it as a verb. We now Google things, and we may Google things even if we're not using the Google search engine. Many courts would have at least found that argument something to chew on, right? Would have at least found it somewhat persuasive. But thankfully, in the District of Arizona, the court rejected that argument, noting, referring to rhetorical and linguistic terms, that it cannot be understated that a mark is not rendered generic merely because the mark serves a Synecdochean dual function of identifying a particular species of service, while at the same time indicating the genus of services to which the species belongs. And the court gives Photoshop as an example, that you can say Photoshop small p as classifying the group of photo editing software or the act of photoshopping, Photoshop capital P still referring to the brand name. And then the court concludes, and so will I, by saying a genericism inquiry guided by grammatical formalism is incompatible with the intent of the Lanham Act, the Lanham Act being the U.S. Federal Trademark Act. Plaintiff's reliance on a Procrustean grammatical standard is misplaced. The dispositive inquiry is whether a majority of the consuming public considers the primary significance of the mark to be an indication of origin rather than an indication of nature and class. And of course, public continue to understand that Google, capital G, was a trademark. So I think the continuing challenge for litigants is to get judges to think of themselves not as confused consumers and not as folks who need help exploring and playing with language in this regard, but as engaged, playful users of language themselves. And in fact, one of my colleagues, a scholar at NYU, has suggested that the best way to find the judges who are more likely to recognize this playful use of language that we all engage in is to read their opinions. And the ones who actually engage in that sort of playful writing themselves tend to be the ones who will tend to recognize what it means to be a reasonably linguistic adept consumer in U.S. trademark law. Thank you.
Okay, let's open it up to some questions or comments from the floor.
I wanted to pick up something that, Alex, you were talking about, which was the question of the average consumer for the purpose of proving applied distinctiveness, and in particular who the average EU consumer is, because it does pose quite an evidential problem when, in the context of prosecuting a community trademark, you're told that you have got a non-distinctive mark and you've got to establish sufficient recognition or significant understanding that it is a trademark across the whole of the EU. And in fact, it comes up similarly in litigation infringement proceedings, picking up Richard's judgment in Enterprise in terms of when you're entitled to have a pan-European injunction, and how far you have to go to persuade a judge that the average EU consumer will be confused, for example.
Should I react to that? I think that's a valid comment that that just talking about the average consumer as defined by the Court of Justice does not give an answer to many other questions which arise. And in the acquired distinctiveness, you have the point that I raised, that is what is the substantial proportion of the public, which you must prove and how you prove it. And you have your point, that is the territory in which you have to demonstrate the existence of the acquired distinctiveness, and there the standard is that you have to show it everywhere where the distinctiveness is lacking. And if it's a 3D mark or color mark, you have to show it everywhere in Europe. And then the question comes up, well, what does that mean? How you define, do you use markets or countries? The Court of Justice, in a very apocryphal statement, said something, it may be too excessive to require proof in every country. But it didn't really tell you, well, to which degree this excess is actually gives an answer to what else you should do. The current situation is such that for marks which are essentially non-distinctive everywhere, colors and shapes, it's practically impossible to get a community trademark. And on reputation and other issues, of course, same issue arises. Where do you have to show reputation among the substantial proportion in order to get relief? And can you get beyond the territory where you have been able to demonstrate it? Is there a presumption, and who has the burden of proof? All of these issues come into play as well.
Jonathan Turner. I have to say this, I was rather disturbed by some of the comments. Particularly, I thought, with due respect for Mr Justice Arnold's comments, it seemed to me to be rather chauvinistic and insular. I appreciate you talking about passing off the an unanswered question as to whether we ought to comply with a directive on unfair commercial practices requires us to adopt certain standards or not, but leaving that aside, passing off a national base still. But I got the sort of general idea or sense that the concept was invented here in Britain first, and those Johnny-come-latelys on the other side of the channel will soon recognise that we've been right all along, so we'll just carry on as we were. And then I heard from Professor Mullendahl that not chauvinistic approach himself, but saying that there's a tendency in German courts to carry on as they have been. And I would pose the question as to really how much deference should be made to attempts to harmonise the law and the approach throughout Europe with a view to providing industry with a uniformity in that economic area which will facilitate economic commercial operations without having to work out in each different country what's going to happen when there is an argument about the mark branding that they're using.
Well, let me respond to that. I certainly wasn't intending to be insular or chauvinistic, and I wasn't intending to imply that I was regarding the Court of Justice as catching up with English law rather late in the day. The point I was trying to make was actually a slightly different one, which is that it's an inevitable question in this field. And when I say this field, I speak both of trademark law and unfair competition law. You are inevitably faced with the question of how protective are you going to be? And that inevitably involves consideration of the characteristics of the people whom you're trying to protect. Now, whether we are speaking about trademarks or we are speaking about unfair competition,
we are, of course, concerned with two dimensions. There's protection of the rival trader, there's protection of the public, and both of those feature in both contexts. You are inevitably forced to take a viewpoint on the question of how much care and attention you think the public is going to pay when you are considering questions of likelihood of confusion. You cannot escape that question. It is simply inevitable. Likewise, you cannot escape the question of considering what do they know about the characteristics of the market. And so therefore, you are forced into the considerations of these questions. And my point about referring to a case of 1876 is really to drive home the fact that even in an embryonic state of our law, judges were confronting these questions. And they were confronting these questions because they're inherent in the subject matter. Now, the other point I was trying to get across is that courts in this country, and I think it's true in most developed systems of law, have always taken the view that there are two problems that you are trying to avoid. You are trying to avoid overprotection and you're trying to avoid underprotection. If you assume too much care and attention, too much knowledge on the part of the consumer, you're going to underprotect the trademark owner, the rival trader. If, on the other hand, you take the opposite view, you're going to overprotect, and so therefore you have to strike a balance. Now, that is inevitably, in my view, going to be a fact and context-sensitive question, which will vary from case to case. But the basics of the approach are inherent. And as it seems to me, the essence of what the Court of Justice has done in its case law from Gooch, Spring and Hyder onwards is to bring to bear these elementary considerations upon the two fields with which we are concerned, and to say that everybody in Europe, in answer to your last point, must be applying the same approach and the same standard, albeit that the results will be facts and context specific.
Are there any further questions?
Hi, Graham Williams. I'm a market researcher, so I'm in a minority of one here, I expect. And I get involved in carrying out these evidence surveys, and I come up against issues around the quality of the data and so forth. That's not the question I have tonight. I think that the question is this average consumer, whether they're reasonably informed. And in the kind of work that I do, working across most consumers, it's not really whether they're well informed, it's whether they care or not. And I think, and at different times in the consumer purchasing process, sometimes they care, sometimes they're well informed, and other times they really are so pixie-ish that they will be willfully mistrustful of brands. So the question I have is this kind of reliance on this well-informed is a kind of a very narrow group, and I think my argument is that most people who are well-informed aren't actually typical of the average consumer.
I'll give an initial response to that, and then I'll let someone else speak. I think the question raised is a good one, and translating it into my own terminology, what I would say is, I think it's a mistake to suppose that because we are concerned with the average consumer, or to use the wording from 1866, the ordinary consumer, the ordinary purchaser, it's a mistake to suppose that people are therefore deemed in some way to be homogeneous. They're not. Consumers come in all shapes and sizes. I mean, Alex put on one of his slides some demographic data. And consumers are heterogeneous in all kinds of ways. And it seems to me that courts deciding trademark and unfair competition cases ought, and generally speaking do, recognise that reality in one way or another. The caveat to that is the point that Alex raised, which is, do you regard this as a question of fact or as a question of law? Now, the English legal tradition has been to regard likelihood of confusion as essentially a question of fact. Yes, of course, you've got to frame the question in the correct legal manner. You've got to approach it on the correct legal basis, apply, legally speaking, the correct test. But once you've done all of that, it's a question of fact. In other words, to put it in different terminology, it's empirical. Historically, some other legal systems have regarded, particularly in the field of trademarks, as distinct from unfair competition law, it being a question of law and therefore applying a legally defined standard which is defined essentially in an abstract and a priori way. I think perhaps one of the more significant effects of the Court of Justice's jurisprudence, and others on the panel may take a different view on this, is to say, actually, the view that it's a question of fact and an empirical question is the correct one. It's not a legal question at the end of the day, albeit you've got to approach it in the legally correct way.
Let me just add, if I could, just a note to that. When we analyze these questions in the context of disputes or cases, we're doing so in a fairly regulated, sterile environment, either the courtroom, the judge's chambers, the survey, or the test, which is done in a sort of artificial way, hopefully approximating as closely as possible the real environment, but it is in fact artificial. I think what's important and where sort of your field and others can contribute to the research here is not simply analyzing, so what do consumers do when faced with these two marks, and how do they analyze them and how do they compare them? But then what decision-making process do they make and engage in thereafter? So what does a consumer do when confronted with these things? Do they care? Do they engage in additional research? Do they try to obtain additional information? Do they try to correct for some of the confusion that might be initially created? And I'm not sure that we've actually seen in the literature and elsewhere enough thinking and discussion, or at least infusion of that into trademark law, about the consumer's decision-making process after that initial point of contact with the mark.
Can I add something? The issue that Judge Arnold raised on law of fact is very significant. And for me, the question is this actually an issue of European law, whether something like this is a factual issue or a legal issue? Can courts in member states diverge on this very important issue? For example, in Germany, the issue of likelihood of confusion is traditionally seen as essentially a legal question. There are underlying factual findings which are factual, but the ultimate conclusion is one of law. And the consequence of it is that the German Federal Supreme Court, which sits as a reviewing court over our 18 appellate jurisdictions in Germany that do most of trademark cases, will govern or guide the development of the case law. If you make all of this a question of fact, then you are in the situation you currently are with the General Court and the Court of Justice, that the cases spray left and right and you have no understanding of where the Court of Justice would actually go, except for an occasional reference, and then you get references where you get answers that for questions you better had not asked. Because it leaves the situation, I referred to the recent Hau case, where you really don't know what you're going to do with these answers. Now, the standard that the court made in Gut-Springenheit, I think, is a good one, and it should be applied, and national courts in Europe actually do apply it. German courts have changed their case law as a result of this development.
I think one of the assumptions behind that question is that the court should approximate some kind of empirical reality, and I'm not sure that that's always the case because there's strong drivers towards a more abstract test. To begin with, it's a likelihood of confusion test, where in many situations you have to guess if it's an early registration and there's no actual use, how consumers will jump in the future once it starts being used. Or going back to Anna's question, you have to guess across the community trademark territory. So you have to imagine how an average European consumer would react. So there are a number of drivers which push the test in a more abstract, sort of tort-like kind of standard, although with the caveat, as Laura pointed out, that the judge is always also a consumer and will have to sort of try and manage that ambivalence. The other sort of difficulty is trademark law sometimes gives the empirical consumer a great degree of deference, like acquired distinctiveness. And at other points of time, like other areas of infringement, like dilution, you're much more speculative about the way consumers react to it, or inherent distinctiveness. You come up with best guesses about which ways consumers are going to jump. So you talk about consumers differently at different parts of trademark law. So there's a pressure to be abstract and different kinds of consumers inhabiting the system. That's a bit messy.
Well, and I'm sorry, let me ask if I can, just one additional thing that this makes me think of, which is you've also, I think, got to think about to which extent some of these decisions in terms of empirics are driven by judicial economy, right? And so the need, so I think part of, for example, inherent distinctiveness is the idea that on balance we can treat, for example, an arbitrary mark as inherently distinctive and not have to bother with the empirical test of whether or not consumers really would see that in the first instance as a mark, and it's just an administrative efficiency argument. So I think that's going to be driving some of these things as well, is sort of how much time do we want to spend on each of these empirical decisions to get us to a particular result.
I think we better finish at that point. You're all invited to drinks in the City 2 common room up at the top of the stairs. Thank you very much for coming, and thank you also to our speakers.